Good evening, everyone. My name is Pete Eekhout. I'm the Dean of the Faculty for a couple more weeks, I think. But it's a huge pleasure to welcome you all here for Professor Stephen Vaughan's Inaugural Lecture. The Inaugural Lecture is a rite of passage. It's an opportunity for a new professor, though you've been professor for a while, I think, already, so he's late with his lecture, but usually they are, to inform a wider audience about their field of expertise and their research program. Now, I'm particularly delighted to preside at this inaugural. The chairs will, and actually Stephen needs two chairs, not just one. Normally we have one chair, but he needs two. The chairs will introduce Stephen as an academic, but for me, I have to say, this is not like any other inaugural lecture, with all the huge respect I have for all my colleagues and the lectures they have delivered. Stephen is not just a professor in the faculty, he is Vice Dean Staffing and Deputy Dean of the faculty, and in truth, so much more. He's a colleague, he's a mentor, he's indeed a friend for so many of us. And his passion for making the faculty both an excellent but also a very kind place is unparalleled. The energy he devotes to this are truly unique and, as I said, unparalleled. And so I'm not going to speak for very long because there's another introduction and then another introduction. But I do want to sort of acknowledge this and express our profound gratitude. And I know that I speak for the whole faculty, not just for Stephen's research, but for the other work he also does with us. The applause speaks for itself, I think. So a very special inaugural lecture. And the lecture is chaired by two very eminent colleagues. We have Professor Ellen Stokes, who's Professor of Law at Cardiff Law School. Her main areas of interest are environmental law and policy, with particular points of focus on the regulation of new technologies and the relationship between law and the future. Ellen is a founding member of the Future Matters Collective, an interdisciplinary network of academics and arts practitioners. She serves on the editorial boards of the Journal of Law and Society, the Journal of Environmental Law as reviews editor, and the Journal of Property, Planning and Environmental Law. A very, very warm welcome, Ellen. Thank you for joining us. And sitting to her right, Professor Richard Moorhead. He's rather well known here in this house. He is Professor of Law and Ethics at the University of Exeter and an honorary professor at our faculty. He's a former solicitor who has spent his career researching lawyers and legal services and has conducted research for the LSB, SRA, Law Society, Civil Justice Council, Ministry of Justice and others. He runs the influential Lawyer Watch blog and is currently researching the Post Office scandal with colleagues from Exeter and UCL at the Evidence-Based Justice Lab. Richard was elected a Fellow of the Academy of Social Sciences in 2019 and a Fellow of the Royal Society of the Arts in May 2016. So very warm welcome back, Richard. Very nice to see you. So I think Ellen will start with introducing Professor Stephen Vaughan a bit further and then over to Richard.
Okay.
Thank you for joining us.
Thank you very much. It's an honour to be here to introduce this evening's speaker, Stephen, as we celebrate his promotion to Professor and show our gratitude for his contribution to the Academy. Thank you, Stephen, for the invitation and for trusting me not to disclose some of our more embarrassing stories together. Like the time we tried to recreate the Dirty Dancing lift. This evening is particularly special because some of Stephen's nearest and dearest are here with us online and in person this evening, so a very warm welcome to Stephen's family and friends. Stephen spends a lot of his professional time championing others. I know this from personal experience, from his writing, from his teaching, from what his students and his colleagues say about him. Now it's our chance to put the spotlight back on him and his work. Stephen's scholarship demonstrates a deep commitment to making sense of the messiness of the legal world and to giving structure and narrative to aspects of the law that are often overlooked or not given the careful scrutiny that they deserve. His first book on EU chemicals legislation is a perfect example of this, taking as it does an immensely dense set of legal rules and guidance and reshaping our understanding of them, how the law works, what it aims to do, and what it actually achieves in practice. In the book, Stephen's analysis is meticulous and painstakingly vast, and yet, as one reviewer noted, Stephen's tone remains down-to-earth, matter-of-fact, even cheerful. Another reviewer commented that Stephen has mastered the art of storytelling, had the courage to analyse these numerous and lengthy documents without minimising or hiding the true complexity of the matter, and he did so in an insightful, engaging and simple way. It's hard to overstate how difficult it is to do what Stephen is doing here, bringing energy and lightness to serious topics like chemical safety and contaminated land, without ever ceasing to be theoretically original, empirically rigorous and contextually rich. It shows the genuine responsibility he feels to making his work not just sharply analytical, but also accessible to a broad audience. And many of us want to do that or profess to do that, but quickly lose sight of the role of universities in serving the public interest. These are foundational to everything that Stephen does. Stephen has brought to environmental law scholarship a distinctive combination of social science methods and intellectual engagement with the detail and practice of things, not for its own sake, but for what it says about society. This has always been evident from Stephen's earliest work with his PhD supervisor, Bob Lee, on the corporatisation of environmental lawyers. Who has the power within governance regimes and transactional settings? Who more pertinently, where more pertinently do power inequalities come from? How might things be done differently? It is in posing these difficult and oftentimes awkward questions that we see Stephen's integrity as a scholar and his strong sense of self. He doesn't choose the easy path, he doesn't try to emulate, he doesn't shy away, he brings himself authentically, unapologetically and wholeheartedly to his research, teaching, leadership and everyday involvement in university life. His review article, My Chemical Regulation Romance, will go down in history. Will go down in the history of the Journal of Environmental Law as one of the most deeply reflective and personal pieces of its kind, weaving incisive theoretical discussion of the law with personal voice and experience. Now, years ago, I know that one of Stephen's interview questions was, how would colleagues describe you? Now, that is such an awful question to ask somebody to answer about themselves. But I hope, Stephen, this evening, that you get a sense of what your colleagues truly think of you and your work. So in recent conversations ahead of this event, colleagues have described Stephen as empathetically insightful, pragmatically principled, expansively intelligent. They have emphasised the strength and the originality of his scholarship, the way he explicitly places a value on kindness. Stephen, because we know you, we have been changed for good. Now, he isn't perfect, of course. He is infuriatingly overzealous in his use of the Oxford comma. And Richard might have more to say about that. But first, though, congratulations, Stephen, and thank you on behalf of us all.
Thank you, Pete. Thank you, Ellen. After good cop, here comes bad cop. We are here to mark Stephen's taking UCL's chair in law and professional ethics, and it's a particular honour for me, as the first holder of that chair, to be introducing Stephen, to be here celebrating this great moment, because for once in his life, Stephen has come second. I should tell you this because his desire to have me introduce him is not solely or mainly a nod to our friendship and years of harmonious working. No. He wants to relish me looking around the room and noticing that, compared to my inaugural lecture, there are far more people here. And they seem, for some reason, to be far happier. And his second reason is to ask me to be nice about him in public. Stephen knows full well I do not do nice. He, let alone in public. He, on the other hand, he does nice. He bakes, he listens, he emails, he makes good suggestions, he notices insightful possibilities, he makes those good suggestions a second time, he buys thoughtful presents and leaves notes. It's incredibly annoying. A little bit of community built here, another there, is how Stephen works, learning, and he does learn from everybody, and building deftly, quietly, maybe I should say fairly quietly, and most of all, as Ellen said, kindly. So what shall I say about his scholarship? Well, on lawyers and ethics, Stephen has written on everything, from the legal academy and the profession to the transformation of the English legal profession, a critique that is, to use a favourite phrase of Stephen's, complex and contingent. He spans independence and vulnerability in large law firms, one is bigger than the other, onshoring, clinical legal education, how students decide to become which kinds of lawyers, and homophily in litigation teams, both more interesting and less salacious than it sounds. He covers corporate lawyers, legal risk management, and ethical red lines, more of that in a minute, diversity reporting, law firms and CSR, and, really importantly actually, diversity within the British Legal Academy, something which Stephen has taken very seriously indeed, particularly since he arrived at UCL, making, if I may say, a real rather than symbolic difference. And I don't just mean that he's a comp-educated Scouser and a gay man, very out, and if I may say so, very justifiably proud. His best work is, of course, on in-house lawyers' ethics. I say that, of course, because he's written it with me. Stephen is a marvellous co-author. He sorts out your punctuation and provides both thoughtful critique and positive reinforcement. If something is good, it is, in Stephen's words, exceptional. Truly exceptional. Or perhaps it reaches Mach 10 Vaughan and it becomes simply stunning. He has also led me to the proudest of my professional moments. After many months of telling me I'd missed another Oxford comma in the manuscript, our book arrived. Stephen, I said, look at the title page. It says In-House Lawyers Ethics, colon, Institutional Logics, comma, Legal Risk, empty space, and the Tournament of Influence. Is there, I asked, perhaps a missing Oxford comma? Now, Stephen is a great conversationalist, but here was a moment when the silence was particularly golden. The moment was stunning. Exceptionally stunning. He got his own back. Later on, he told me one of the reviewers had not got one of my chapters and how much they'd loved the book's central metaphor, the Tournament of Influence. Indeed, a central idea it was, and I have to tell you, it was his. Let me now offer some unadulterated praise. Stephen has been an exceptional friend to me. I'm sorry, I'm getting emotional. Truly stunning, through good times and bad times. There is one thing I think he does excel at, though, and Ellen's touched on it. He is truly a brilliant communicator, in person and on paper. He has the ability to make one important, sometimes deceptively simple idea resonate and grow. An example is him and Emma Oakley's work on gorilla exceptions and lawyers' ethics. Even corporate lawyers have their ethical red lines, they discovered. They would, for example, draw the line at destroying gorilla habitats for a client. The point was, I think, these exceptions were hypotheticals beyond the realms of likelihood. They could claim them without ever having to cross them. Their professionalism was intact. Now, for me, the beauty of that idea was that it was both resonant and important, deeper than it initially appeared, a kind of philosopher's insight with the pith of a RuPaul catchphrase. What does it mean, he asked, I think, if our ethics are simulations, hypotheticals, simply stories? This intellectual earworm allows both Stephen's ideas and your own thoughts about it to grow. It is an intellectually collaborative, generous style. He doesn't say, aren't I right, like many of us do. He asks, well, what do you think? Tonight, some similarly challenging ideas will burrow its way into our brains, I'm sure. As ever, he will deftly span academy and practice, and I wanted to end with comments from practitioners that know Stephen. Working with practitioners is really important to him. As one says, his unique combination of academic disciplines sits astride the greatest legal ethical issue of the 21st century. It will be the environment where the professional enablers debate will rage strongest and gain the most traction with those coming into the profession. And another, Stephen is one of life's true polymaths. Hashtag that means good with Google. One day talking about thick versus thin concepts of the rule of law, the next how to make the perfect pavlova. There is nothing he doesn't know, cannot do. All I'll say about that is watch Stephen try and be generous and kind when playing netball with colleagues who are underperforming. I have seen that look, it is most entertaining. They go on. He makes academic ideas hugely accessible without doing anything idea. I love his idea, they say, of lawyers as lubricators. Works on a number of levels. Behind this lies a real authenticity and a desire to make the world lawyering, the world of lawyering better. There's that word again, authenticity, and the desire to make the world of lawyering better. On that last sentence, a sentence which even I cannot find anything to disagree with, let us say to Stephen, thank you for that desire and authenticity, and hand the floor over to him. Stephen, oh gosh, sorry, dear friend, thank you very much. And in the words of RuPaul, good luck and... You know the next bit.
Don't mess it up. Thank you. So, good evening. Isn't this lovely? So nice to see so many of you here, both in person and online. My enormous thanks to Pete and to Ellen and to Richard for their kind words, especially to Ellen for not sharing too many embarrassing stories. Richard and Ellen and I have been friends and co-authors and former colleagues for over 15 years, and so it meant a lot for them to chair tonight. They are the sort of academics that I want to be when I grow up, and that is not a backhanded comment about Richard's age. Let me begin with some personal remarks and ask Kat if she's listening, because the PowerPoint is not working, which is unusual for UCL. I come from what is often called a very ordinary family, but there is nothing ordinary about them. They are wonderful and kind and have a very wicked, very Scouse sense of humour. My lovely mum passed away when I was 9, and my lovely dad 10 years ago. They'd have really loved to have been here tonight. But my sisters, Paula and Sandra, are here this evening, and with my brothers-in-law, Ray and Dave. My sisters are strong and brilliant and fearless, the best people that I know. They're also very fiercely protective of their baby brother. And I say this in case you don't like the lecture, and I'd advise you to be careful what you say in the drinks afterwards. Paula and Sandra have between them 5 daughters, and my nieces, who are all adults, often say to me, Uncle Steve, who is your favourite out of the 5 of us? And I tell them the truth, that I love them all equally. And I note, simply for information and not for any other reason, that 3 of my nieces are here in person tonight, and 2 are not. My husband Digby is also here this evening with my mother-in-law Pip. Digby is quietly amazing, a much better person than I am. My friends say, repeatedly in fact, my friends repeatedly say that he has a lot to put up with. I assume they're talking about his challenging day job as a GP. One of the risks of an inaugural is that it becomes in part a long list of names, but it would be wrong of me not to thank Cathy O'Brien, Liz Fisher, Bob Lee, and Joanne Scott, who've been so instrumental in my career, and my very lovely and very supportive UCL colleagues, who I won't name individually because I'd miss somebody and that would be bad. But let me simply say that this is a really good place to work, filled with really good people, and I'm very proud to be a member of this community.
Having just said I wouldn't name names, I do need to thank Kappa Logan from our events team who has helped to put this evening together. Kat is, I know, very disappointed that I didn't walk into a Britney Spears entrance song. I'm pretty disappointed in myself. So some of you, on looking at my title, The Unethical Environmental Lawyer, will have been wondering if this is perhaps autobiographical or a form of self-help. It is both of these things and more. So let me begin with a story that some of you already know, but it is too good a story not to share more widely. After I finished my law degree, I came to London and started my training as a lawyer. At that point in my life, I was single and looking for love. That searching for love manifested in a series of blind dates. On one blind date, I was sat in a bar and met by a very handsome guy. We got to talking about our lives. He asked me what I did for work. I'm a lawyer, I said. What sort of lawyer? He asked. An environmental lawyer, I replied. He smiled. Oh wow, he said, you get to save the whales. There was then a long and very awkward pause. Actually, I said, I'm probably on what you would think of as the whale killing side of the profession. I act for fossil fuel companies and for arms manufacturers. The date ended pretty quickly after that. And what I found interesting, as I cried alone into my martini, what I found interesting was the assumption my blind date had made, that being an environmental lawyer went hand in hand with protecting the environment, when in my experience that wasn't necessarily the case. And so when thinking about what I talk about this evening, I decided to bring together the two areas that I research, environmental law and lawyers' ethics. What I'm going to do tonight is to suggest that some of the environmental harms that lawyers help their clients create, harms permitted by the law, that those environmental harms raise important and significant questions about the ethics of that lawyering. Do lawyers help to bring about environmental harms that cost society too much? And does legal ethics help or hinder those actions? Why are these questions important? Well, partly because of the seriousness of the environmental harms that we face, partly because of the roles that lawyers play in facilitating those harms, and because key to the legitimacy of lawyers' claims to professional status is, as Richard Moorhead said in his own inaugural, a manifest and demonstrable commitment, both in principle and in practice, to exercise their knowledge and skills primarily in the public interest, placing the public interest above both self-interest and the interest of their clients. As a species and as a planet, we're facing a whole series of significant environmental harms, many of which are only going to get worse over time. Climate change, air pollution, biodiversity loss, chemical harms, waste pollution, poor water quality, and so on. Somewhere in the story of each of those environmental harms, and in many other stories, are lawyers. In those stories, the lawyers take on various roles and they do various things. They work in law firms, large and small. They work for governments and regulators as civil servants. They work in-house in large corporations and for charities. These lawyers make things happen. The buying and selling of fossil fuel companies, the financing of oil fields, the shipping of waste overseas. Lawyers shape and negotiate future environmental laws through lobbying on their clients' behalves. Lawyers draft and deconstruct environmental legislation and also advance and agree legal meaning in relation to environmental law in contract. Lawyers advise on how changing environmental regulation can impact on and provide opportunities for their clients' businesses and interests. Lawyers also take part in the adjudication and arbitration of environmental law disputes, creating winners and losers and setting meaning via precedent. Now, at this point in my talk, I'm not saying that we could or should hold some of those lawyers responsible for some of the environmental harms with which they are associated. That comes later. My point for now is simply a factual one, that lawyers are everywhere and that they are intimately connected with environmental harms. Let me set out what I'm interested in and what I'm not. I'm not interested in things that lawyers do that have environmental consequences which are clearly illegal. So one real-world example would be lawyers who obstructed the Environment Agency in a manner which the courts found to be criminal. Such a legal action is significant but not very intellectually interesting. I'm interested instead in matters in which lawyers are involved, which have some legal basis, and where there are environmental consequences. Lawful but awful, to borrow a very blunt phrase. And in those lawful but awful situations, the conduct of the lawyer as a lawyer is also more or less concerning. I'd like to divide those conduct cases into two, into the prima facie or very obviously problematic cases, and the more difficult and not so obviously problematic cases. So let me give you some examples of the prima facie cases from the UK and beyond. So what have we seen? We've seen lawyers bringing libel claims and fraud counterclaims against environmental defenders. We have seen lawyers threaten to remove statutory protection given to environmental groups when court decisions go against the government. We have seen lawyers loophole lawyer on the international climate regime's clean development mechanism. We've seen lawyers deploy legal intimidation tactics for a mining company that are said to be a threat to democracy. We've seen lawyers engage in bullying techniques directed at university environmental law clinics. In each of those prima facie problematic examples, and in many others, we have lawyers acting as clever lawyers in relation to environmental harms. These are situations which strike me as problematic, but where, so far as I can see, no action has been taken by a regulator or a court to suggest that, in fact, that lawyering crossed a professional conduct line, lawful but awful. And then we have other cases, the more difficult problematic cases, in which lawyers are part of the narrative of environmental harms. They're in the room where it happened, and where their lawyering was, as a starting point, well within the bounds of acceptable professional conduct. Here, there is fascinating work by the activist group, Law Students for Climate Accountability, that shows how between 2015 and 2019, the top 100 law firms in the US had worked on 10 times as many cases exacerbating climate change as addressing climate change, that those law firms were legal advisors on 5 times more work for the fossil fuel industry than the renewable energy industry, and had lobbied 5 times more for fossil fuel companies than renewable energy companies. So we have these lawyers who are intimately connected with environmental harms. How might then we assess the ethicality of the work that they do? When we talk about ethics and lawyers, we are often talking about a whole range of different things. First, we can talk about professional conduct and the rules written by the regulators of lawyers that seek to shape how lawyers act, so legal ethics put onto paper. Second, we're also talking about the theories of ethics that have been developed for lawyers in particular, and where those theories seek to provide schemas for justifying or not justifying the actions that lawyers take as lawyers. And third, we have what's often referred to as ordinary morality, the morals of everyday people, and whether or how or if that applies to lawyers as well. And I explain the broad difference between legal ethics, a form of role morality, and ordinary morality by asking my students if they would like a murderer as a friend. They usually say no. I then ask if they'd be willing to defend a murderer if they were a lawyer, and they usually say yes. So what I'd like us to do is to think about lawyers, their connections to environmental harms that their clients make, and explore lawyers' actions by reference to professional regulatory rulebooks and by reference to those dedicated theories of lawyers' ethics. Now, I imagine that one of the outcomes from tonight is that some practicing lawyers will feel pretty uncomfortable, perhaps even angry by the end of my lecture. That's not my goal, but it's not something I'm embarrassed by either. What I'm saying now, or I'm not saying now, or later, is that lawyers are bad people. I mean, some, of course, are bad people. That's in the nature of any large population. But my focus tonight is on what lawyers do as lawyers. So far, I've been using that word lawyer as a blanket, as a shorthand, but my focus tonight is primarily on solicitors. I won't say all that much about barristers, save this throwaway incendiary comment that I think that they plead the cab rank rule far too often as a justification for the work that they do. So on to lawyers' ethics written down, about the way in which the Solicitors Regulation Authority, the SRA, regulates the conduct of solicitors. To pray see what follows, while I think the SRA's rules are pretty useful for the very obviously problematic cases, the lawyers who bully or cheat or loophole, we need to think much more carefully about the SRA's rules in other cases. In the example of clients saying, please buy this oil field for me, where there is no clever lawyering. When it comes to legal ethics written down, the SRA takes a three-pronged approach. It sets out high-level mandatory principles, it has a series of detailed topic-based rules on conduct, and it has a statement of competence. And in each of those spaces, it also produces guidance. I'm going to focus on the SRA's principles tonight. They are given form in the SRA's STARS, its standards and regulations, and are based on the Legal Services Act and on previous professional codes. The SRA, the regulator, says that its principles, quote, comprise the fundamental tenets of ethical behaviour that we expect all those we regulate to uphold. Or, as the chair of the SRA board put it in 2007, the principles set out what should be at the heart of what it means to be a solicitor. One of the many things that's interesting about the principles is that they apply to everything that a solicitor does. They are pervasive and mandatory. They are also not ranked. So what do they say? Well, the principles say that solicitors should act in a way that upholds the constitutional principle of the rule of law, in a way that upholds public trust and confidence, with independence, with honesty, with integrity, in a way that encourages equality, diversity, and inclusion, and in the best interest of each client. The regulatory scheme of professional ethics that the SRA sets out in these principles is very unusual in that it accepts a very particular form of justice, one that is uncommon among other common law legal services regulators. What the SRA does is to make compulsory a form of socially responsible lawyering. So let me explain. Nowhere, at no point in these principles or elsewhere in the regulatory toolkit, does the SRA say that the client comes first or takes precedence. Now, my own research makes clear this often comes as something of a surprise to practicing solicitors. Instead, what the regulator says is that a complex of things, the rule of law, independence, and so on, operate in tandem, together with acting in the best interest of a client. What the regulator also does is to set out what should happen when its principles rub up against each other. Should the principles come into conflict, the SRA says, those which safeguard the wider public interest take precedence over an individual client's interests. So what I'm going to do now is to take some time to think about the SRA's principles, both in general and in the context of environmental harms. And I'll begin with some brief comments about independence and integrity before focusing in more depth on some of the others. So independence is a principle which tries to see lawyers as mediators between their clients and the state. In one direction, professional independence means that lawyers should protect their clients from unwarranted state interference. And in the other direction, independence means that lawyers should be acting as brakes and limiters on client action. Integrity is thought to denote a higher moral standard than honesty, requiring a moral soundness, rectitude, and steady adherence to an ethical code. Professional principles like independence and integrity, also honesty, what they do is to temper a solicitor acting thoughtlessly on a client's instructions. And we can be confident that what these principles mean is that there are limits to what lawyers can and should do when it comes to advising on potential environmental harms, and that clever lawyering, bullying and cheating and so on, will often be outside those limits. And the regulator accepts this. It says as much in its recent guidance on NDAs and also on the conduct of litigation. Now, there is sadly nothing new about me saying that these principles temper lawyer action, save that that sort of tempering and those sorts of limits are not very helpful for when the environmental harms that what clients want to do are clearly legal and where the lawyer is acting well within the ambit of their principles. The client says, please buy these oil fields for me, and the lawyer does just that with no loopholing or bullying. The SRA's other principles are, however, more interesting. Martin Krieger says that the rule of law is not a thing like a stone we might stumble over, but a complex, practical ideal. I think that's really important and also something many practicing lawyers often forget. What I mean by this is what lawyers often do is wave the rule of law around like a flag, assuming that it, the rule of law, is this easy, neat, agreed upon thing, and that also it conveniently supports whatever arguments they are trying to make. This is a problem because those lawyers don't seem to get the complexity of this contested thing we call the rule of law and what it might or might not mean. And yet perhaps at the same time, lawyers not appreciating the complexity of the rule of law is no surprise. As Jeff Twentyman, who is a partner at a Magic Circle law firm, has observed, the rule of law can, quote, cast a long shadow under which commercial solicitors occasionally and conveniently shelter from daylight. Given a lack of regulatory guidance on the rule of law, given competing views on what actually constitutes a professional commitment to the rule of law, practicing solicitors will need to decide for themselves what the rule of law means. This will depend on whether one subscribes to thicker or thinner accounts of the rule of law, to which laundry list, as Jeremy Waldron so vividly put it, to which laundry list of rule of law desirables one subscribes. A thinner formal or procedural understanding of the rule of law would see lawyers do all that they can to advise on and enact the law as drafted, to give effect to rule of law ideas of legal certainty and legality. However, that's one thing when the law is settled and clear, but another where there is scope for interpretation and the exercise of discretion by a lawyer, or where the law is frequently changing. How is this relevant for environmental law and environmental harms? Well, Kerry Warnock has said that legal certainty, one core aspect of thin or procedural takes on the rule of law, is harder when it comes to environmental law problems. This is because, as Jonas Eberson has written, identifying what the law requires in environmental issues involves a complex weighing exercise of statute, which is often open-textured, precedent, principles, guidelines, international norms, and so on. Equally, as Liz Fisher, Eloise Scotford, and Emily Barrett have framed it, climate change's highly polycentric, uncertain, and dynamic nature presents particular challenges for legal orders and adjudication, including for thinking about the rule of law. What we might also want to reflect on is the fact that some academics argue that the UK's Climate Change Act can be seen as constitutionally important and perhaps contains fundamental norms, the protection of which are crucial to the rule of law. So what we have is this legally disruptive nature of climate change, the open-textured nature of much other environmental law, arguably the constitutional importance of the Climate Change Act. These things and other things make more complex and messy ideas about what lawyers committed to upholding the rule of law should do when it comes to advising their clients about environmental harms. There's also possibly something really powerful here about environmental justice and rule of law values, which brings me on to the next of the SRA's principles. Here we have a principle that requires solicitors to act in a way that encourages equality, diversity, and inclusion. Well, this is interesting given that we know really well how some environmental harms repeatedly impact on some groups more than others. Climate justice in the global north, global south, air pollution and black communities in London, Cancer Alley in the US, etc. Imagine a client comes to a lawyer and asks for help with the permitting of new coal-fired power plants in a country where coal-fired power plants are legal and encouraged. Given the lawyer knows, or should know, about how climate harms globally impact women and people of colour much worse than other groups, is that lawyer encouraging equality, diversity and inclusion when they give life to their clients' instructions? We move on to acting in the best interest of a client. Well, in considering what is or is not included in a client's best interests when it comes to the potential environmental harms of a client's instructions, I think lawyers will likely want and need to think about the long term as well as the short term, the scope of directors' duties in an age of CSR and ESG regulation, and the challenges to a client's social license to operate in addition to other things. And so because of that, I think it's not unreasonable to say that the obligation to act in a client's best interests, given what we know of these increasing regulatory, financial, and reputational risks to clients from environmental harms, even when they're legal, means that lawyers should be thinking beyond getting the deal done and should be engaged in active client counselling. We might see this as an expanded form of climate-conscious legal practice, as Kim Bua and Brian Preston have put it, where such environmental consciousness is simply a consequence of the principle to act in a client's best interests. So given what I've said so far about the SRA's principles, I don't think it's very much of a stretch to say that independence, integrity, acting in a client's best interests, and so on, likely require some active lawyering by solicitors including forms of client counselling about the perfectly legal environmental harms their clients plan to bring about. I noted earlier how the public interest can act as a tiebreaker in situations in which the SRA's principles come into conflict. There is something potentially very powerful here about the public interest and what that might mean in the context of environmental harms. We have recent UN recognition of a human right to a healthy environment. We know what awful impacts environmental harms do and can have on society and multiple forms of the public. We also recognise the environment as a relevant stakeholder in lots of different ways. Section 172 of the Companies Act, giving standing to environmental NGOs, the granting of legal personality in some instances. Giving those things and others, when will it be in the public interest for lawyers to bring about perfectly legal environmental harms on behalf of their clients? There are sadly two big problems here. The first is that the public interest only gets engaged when the principles come into conflict, and it's up for debate when, how, or how often that would happen with perfectly legal environmental harms where the solicitor wasn't doing any form of clever lawyering. And the second problem is what Maria Lee has called the uncertain and contested nature of public interests, and what we should or might do when environmental protection rubs up against things like the economy, or defence, or food, or health provision. If we add in temporal challenges, what the public interest means now, or for different futures, and geographical challenges, which publics, whose interests, this makes scoping out the public interest when it comes to environmental harms really hard. Let me recap what I've said about lawyers' ethics written down. While the SRA's principles are pretty useful when it comes to tempering and seeking to prevent what I've labelled tonight the very obviously problematic cases, lawyers who bully or cheat, the most the SRA's principles probably require is client counselling when it comes to the perfectly legal and well-lawyered environmental harm-causing matters. And if that sort of counselling is given by a solicitor, we really don't think you should buy these oil fields for the environmental harms they will create, but that advice is ignored, well, what then? Let's keep that in mind as I turn to the competing theories of lawyers' ethics. I was quite intentional in my use of competing in that previous sentence. In the things I'm going to talk about now, none of them is valid in the sense of being a universal truth that everyone agrees with. They are not. Instead, they are different and mutually exclusive attempts by academics to think about the particular position of lawyers in society and to create and then substantiate frameworks that tell us how lawyers should act. What we also need to remember is that the SRA's principles I've just talked about are not maximums. They are instead the baseline of ethicality required by the law, where the SRA's rules provide minimal standards of acceptable conduct and simply bound off behaviour which is clearly unacceptable. And so what we can do is use theories of lawyers' ethics, both as what might be required or needed beyond the SRA's baseline, or to challenge what we might think of as deficiencies in the SRA's approach. As the Solicitor Disciplinary Tribunal said in the case of Sims, a solicitor, quote, must and should on occasion be prepared to say to his client, what you seek to do may be legal, but I'm not prepared to help you do it. Let's begin with the standard conception. This approach to legal ethics argues that lawyers should do all that is permissible for their clients within the bounds of the law. At the core of the standard conception is a value trinity. Neutrality, it's not for the lawyer to judge their client. Partisanship, the lawyer should do all they can to advance their client's interests. And non-accountability, the lawyer is not responsible for the client's decisions. Some of those who take the standard conception approach do so and argue that we live in a pluralistic society based on competing notions of the public good, that the institutions of law are designed to mediate between those diverse ranges of views, and that it's not for lawyers to determine what we'll do as a community, what rights we'll allocate, and to whom. Others, also in favour of the standard conception, base their arguments instead on a lawyer as a technical mechanic who should respect the autonomy of their client, or on the idea of the civil obedience of a lawyer who obeys the law even when it conflicts with her own morals. A common thread in these accounts is that the moral justification and responsibility for action by a lawyer on a client's behalf lies at the institutional level and not at any lower level. So putting this into the context of environmental harms, the broad standard conception argument would go like this. Maybe I, as a lawyer, do or don't personally like that my client is going to harm the environment, but we live in a world with complex and competing views on natural resources, health, poverty, the economy, and so on. And laws have been democratically made which set out what my client can and cannot do. It's not my job to judge my client for seeking to do things that are legal. Clients get to decide what they want to do, and they need me as a lawyer to help them do what they want to do, even if the environmental harms are really significant. Now, I find the standard conception approach a bitter and hard pill to swallow, as do others. Reed Mortensen says that the approach in the standard conception downplays the moral quality of the value trinity. And so, for example, neutrality isn't really neutral. Instead, neutrality is saying there is a moral value in having procedures embedded in law that allow individuals to pursue different moral plans. And, as I've argued elsewhere with Trevor Clark, Richard Moorhead and Alan Brenner, if the basis for neutrality is respect for the individual as an autonomous moral person, it is harder to see that applies where the client is a company, a legal fiction. What the standard conception also does, and I think does problematically, is to offer up a particular form of justice, small justice, as Rob Atkinson puts it, as the best we can hope for or expect. The best we can hope for or expect because we live in this world of radical normative disagreement. And so the line goes, as expressed by Tim Dare, that because as a society we have such fundamental questions over what constitutes human flourishing, what basic goods are intrinsically most worthy of pursuit, what is the best way for individuals to live their lives, that it really isn't for a lawyer to seek to supersede their views over the views and products of a democratically elected parliament. And so because of this, what a standard conception lawyer can say is, the law permits us, me and my client, to seriously damage the environment, perhaps beyond repair. It is what it is. What I would say is that there is something powerfully unpleasant, repulsive even, in that very defeatist, minimal liberalist sort of take. And I would suggest that the little form of justice that the standard conception preferences and prioritizes is not the form of justice that we need for significant action to be taken on environmental harms. And so instead, as an alternative to the standard conception, William Simon would have lawyers make contextual discretionary judgments about justice. Here, and in line with Ronald Dworkin, justice is a synonym for legal merit, with lawyers analysing the law in light of fundamental legal values and principles to arrive at substantively just outcomes. From this perspective, law and morality are not highly differentiated, and consequently, lawyers must act in the interests of their client, but are obligated to do so in a way which accords not merely with the letter of the law, but also with the law's inner morality or purpose. These are the responsible lawyers who have both a counselling and gatekeeping role, which extends beyond the standard conception, zealous advocate, or neutral technician roles. What might responsible lawyering look like in practice? Well, the responsible lawyer would be much more active with their clients in terms of counselling about environmental harms and on the impacts that using the law in a certain way would lead us to. A responsible lawyer would robustly defend their professional independence and accept their place mediating between client and state, and so they wouldn't just take at face value their client's instructions. And a responsible lawyer would not use loopholes or minimally arguable points to frustrate the purpose of the law. I wonder if they might also, and this is a throwaway tease for later, I wonder if the responsible lawyer might also reflect on something I spoke to earlier, the arguably novel constitutional nature of the Climate Change Act, whether that act might be a superstatute, which means that other laws which permit environmental harms should or might be read in light of the CCA's objectives and spirit. So when a lawyer says, what I'm doing for my client is perfectly legal, including the associated environmental harms, we'll want to think, as we've just done, about that line in relation to professional ethics written down and also lawyers' ethics more generally. But a related and very important question is, yes, but why did you take on the client in the first place? Here, I'm not sure that lawyers' ethics, either in the SRA's principles or more generally, actually really has anything to do with the question of whether to act for any given client. Law firms and their lawyers will ask themselves, should we take on a client, by reference to the law, is what the client's seeking to do legal, by reference to their more general professional obligations, are there conflicts and so on, and by reference to individual or firm level morals, capacity, issues of expertise and profit. Now, in response to that question, well, why did you take on the client in the first place, there is something that lawyers who work in large law firms say a lot, and it's that everyone deserves legal advice. Now, I find that interesting for three reasons. The first is it's very much the active choice of a law firm whether or not they decide to take on a client. No one forced them. And the reasons that law firms have for choosing clients may be varied. And we may also see variation between what law firms say in public about the reasons they take on their clients and the things they say in private. Here, Deborah Rohde has suggested that lawyers have the ability to repackage occupational interests as societal imperatives. And so I wonder, do we sometimes see the vice of environmental harms and associated law firm profits dressed up by lawyers as the professional virtue of providing neutral legal advice? The second thing I find interesting about that line, everyone deserves legal advice, is that it presupposes, I think, a legal system in which there is some form of equality of arms. And yet, as we know, access to justice depends on resources. And Christine Parker has reminded us that economic strength can have a destabilizing effect on the integrity of the justice system, and we see this made very tangible in the earlier examples of lawyers engaging in environmental lawfare. At the same time, if law firms say, you can't associate me with my oil and gas clients because everyone deserves legal advice, then I think we might want to take a very close, very hard look at just exactly how much pro bono that law firm does. When a law firm says everyone deserves legal advice, are they really just saying everyone who can afford my £1,000 per hour charge-out rates? The third thing I find interesting is that everyone who says everyone deserves legal advice, those lawyers are often deeply, deeply hypocritical. The line, everyone deserves legal advice, would be much more palatable if I think lawyers actually acted on it, but they don't, and we know that they don't. So in one project that Richard mentioned earlier, the corporate lawyers that Emma Oakley and I interviewed repeatedly told us it wasn't their job to judge what their clients did. They were simply neutral providers of legal advice. It was clients who took decisions on how to act. What was interesting was that many of the interviewees, despite acting very happily for company A or company B, where others might have moral issues with those companies, still had their own very personal, highly individualized red lines, and we decided to call them, as Richard said earlier, the gorilla exceptions. Although I now think actually we should have called them the meatloaf exceptions, because what the lawyers were saying is, I'll do anything for my clients, but I won't do that. Let me give you two examples. One finance partner we interviewed was absolutely clear that his job was not to judge the actions of his clients. His clients could engage in whatever was legal, including tobacco work, which he would very happily do for them. But he went on to say this: in spite of everything I've said so far, I do have a very strong view about environmental protection and animals in particular. If somebody came to me and said, we've got this amazing mandate to build something in the DRC that's currently home to 500 gorillas, I might struggle with that a bit. A different corporate finance partner said to us that he did not, and I quote, care if my client's solar panels are made using slave labour, and then he went on to say that he also could not do any work for gambling companies. So what these examples and many others suggest to us is that the commitment of certain lawyers to respect for the law as a neutral field in which their clients play and deserve legal advice may be somewhat constrained. We also have a more recent example of meatloaf lawyering. Think of how earlier this year many London law firms began one week by saying everyone deserves legal advice. We will continue to act for our Russian clients. And then by the end of the following week, they dropped all of those clients. What we see in the meatloaf exceptions, and what I think we'll see more and more of when it comes to environmental harms, is what we might broadly call own interest conflicts. Some kind of roughly conscientious objection by a lawyer or a firm to a particular client or matter. There is more work and thinking to be done on the human condition, on how these lawyers' red lines differ, on what John Rawls calls the burdens of judgment. Work for tonight, not for tonight, not enough time tonight, but important work nonetheless. We are almost there. Some final thoughts. Let me end with some key messages. The first is that, as well as being servants of their clients, lawyers also have agency to bring about or not bring about or mediate environmental harms. And look, I get the agency is constrained, but it's there. And I think we hear and I think we read far too much about lawyers as simple, neutral, technical facilitators of their clients' desires versus lawyers as active designers and structuring forces, creating, innovating, and influencing client decision-making. Second, there is important work to be done by law firms, by regulators, by representative groups when it comes to reflecting on the perfectly legal harms that lawyers help to bring about and which have associated environmental harms. And the Law Society started some of that work, which I'm very pleased to see in relation to climate change. I hear of a handful of law firms who are doing this, having these hard conversations behind closed doors, but it really is a handful. Third, we are probably pretty likely as a group to disagree on exactly what the SRA's principles mean or require, and/or on which approach to legal ethics is best or most appropriate. But let's at least have the disagreement. Let's not have it on Twitter. Let's bring these important and very difficult questions out into the open. Finally, if you find yourself on a blind date, let us all hope that you've made sufficient choices that the good-looking individual on the other side of the table comes to the conclusion that you are on the whale-saving side of the profession. That's probably a better outcome for your evening and also for the planet. Thank you very much. Thank you.
Thank you, Stephen. I'm getting, it's getting on my voice, actually. Ladies and gentlemen, it's a rule at UCL that at an inaugural lecture, there are no questions. There's no opportunity to ask questions. I cannot tell you what the origin of that rule is. I do think that in the present circumstances, it's a proper rule because I would fear that we would be here for a very long time and that this would keep you away from the drinks, which we have, I think, upstairs. So all that remains for me to do, but that's really very important and significant, is to say on behalf of the Faculty of Laws, I now formally inaugurate you, Stephen Vaughan, as Professor of Law and Professional Ethics in the Faculty of Laws at UCL.
Thank you.
Congratulations. Thank you.